1408 does, which basically it provides a way that a dissolved limited liability company can basically post a bond and say, you know, here's what we think our creditors are going to, or here's what we think our creditor claims are likely to be. We don't want to deal with ongoing liability, and therefore we should be able to just post a bond and walk away from the entity. Now, I took a look at states that have adopted this, and there really aren't very many, or really none. Washington didn't, Delaware didn't. You know, and I think the idea is that it's a pretty big departure from what we currently do, as far as putting, you know, attaching liability to assets that are being distributed out in dissolution of the entity. You know, I can see why it would be attractive as an option, and certainly has permissive language that, you know, in Section A of Section 706, which says a limited liability company may do this. But I can also see why, from a creditor's perspective, it may not be the best option, because you may not, they're basically supposed to provide notice. A dissolved limited liability company shall provide notice not later than 10 days after the filing of the application to each claimant holding a contingent claim known to the company. So, you know, I think that the notice is intended to give the creditors the opportunity to go before the court and say, hey, this is not sufficient amount of security for the liability that may become due. Also, you may have situations like Superfund sites that don't become known until many, many years after the entity is dissolved. My recommendation would be that we not adopt 706, just because I think we're trying to reflect current policy perspectives from, you know, as far as what the Oregon legislature has decided, but also that, you know, the other states don't appear to have adopted this section. And so we would be kind of out on our own if we were to adopt it. Thoughts, concerns?
I agree that we should not adopt this. I mean, it doesn't make any sense to me other than as a gotcha, because there are a lot of types of claims that are contingent.
Yeah.
And I could see some real potential for abuse of this, where somebody would say, well, I'm going to put up $100,000 for security, even though I know I have $25 million of contingent liabilities out there. And I'll hope that my creditor's asleep and doesn't come in 10 days and say something about it. And then I'm not going to have to pay any of it.
Right.
Yeah, it's too cute by half for me. So I would not agree to adopt this.
Yeah, I mean, it's a big change from current policy. And I do think that if this is something the legislature wants to revisit down the road, you know, if more states decide to get on board with this, they certainly can. But, you know, even Delaware doesn't have this. You know, I looked at a couple of states that adopted the Model Business Corporation Act, and they don't have it in their revised Uniform LLC Act either. So, like Nebraska, for example, has both, and they didn't adopt it. So any questions, concerns, thoughts about that? Anything else? Anybody love this, want to keep it?
Valerie, just for the notes, we're just completely striking 706,
yeah.
Correct? Okay.
Yeah, and it operates fairly independently. I was looking at the references to, you know, in other sections, and it operates pretty independently, just as sort of this bolt-on in the act. So I don't think it's something that we need to worry about, you know, causing other structural problems within the act. All right, hearing no additional objections, I'm just going to exit out, and then we'll talk with Sean when we have a conversation with him, which hopefully will be shortly after this legislative session, although who knows how this legislative session is going to go. So I'm sure it's going to be a barrel of monkeys. It's not like there's anything going on, right?
Valerie, if we do delete that,
yeah.
Do we have to make any changes to, what is it, 705?
It refers to 705, But 705 is very similar to what we have already in 63-644 and 63-645. It's just an additional bolt-on where it would give the members of a dissolved limited liability company the option to basically walk away with their assets if they post the security. So I don't think we have to make changes.
Well, I mean, at
We
minimum,
might have to renumber because.
Well, and we have, I mean, at the bottom of
And there's some cross references.
yeah, there's
Yeah,
some
there's
cross references we'd have to take
references
out, but you know, I don't think Sean's going to be, yeah, I mean, we could, I crossed out the cross reference in D2 of 705, but
There's a bunch more, but you know, that's clerical, really.
Legislative council will pick up all that stuff when they
Yeah.
read this.
yeah,
But
I didn't think
they're
there was
good at
anything.
that.
I didn't think there was anything structurally dependent on 706 though. So, you know, I just think it was an additional, well, if you want to do it this way, then you can.
I'm gonna put a special note for LC to make sure they delete the cross references, but they're as Teresa said.
Yeah, I mean, I
they're
think
great at that.
there's a couple other sections that we've deleted as we've gone through here, just for policy reasons, you know, paragraphs and stuff.
Mhm.
And they're gonna have to do all that with respect to those paragraphs as well. But yeah, I mean, if it's something that a particular legislature feels strongly that they want, then they can make that policy decision. But I think it puts us too far out over a cliff. And I agree with Teresa. I don't know that we get enough back for it to make it worthwhile.
Valerie, just so I
Yeah.
wasn't advocating keeping it.
No,
Moving
I
it.
understand.
Okay.
I understand. No, I just, you know, just thinking about process, because what we do here is going to have to then go to Sean Brennan, who's going to have to fiddle with stuff and make it consistent with our style. So, okay. Anything else before we hop on to this? So I think we did 708 for the most part and went through, and it seems pretty non-controversial. We updated the dates to be consistent with what they are currently. And then, so I think we're okay. Again, there's more cross references in here, but I think we're okay with 708. Did anybody else have any questions about administrative dissolution? I know, Ruth, you were going to go back and take a look at that and just make sure there wasn't any heartburn. You're muted.
Sorry, I was in another screen looking at it. I don't think there is.
Yeah, I mean, it's pretty similar to what our current process is, as long as we get rid of some of these references and then update the timeframes. And I think we talked about adding in language from ORS 63-647.
My notes, Valerie, my notes indicate that we were going to be adopting 647, 3 and 4 and 5, but or 3 and 5 at least. But I thought we're looking at whether we should adopt 647-6 or not. Or at least that was the only outstanding question my notes indicated on this section.
Yeah, Cody, just to let you know, I have the same thing. They were definitely adopting 3.5, and we had discussed 6, but I have no definitive on that.
Yeah, and that's just the period of duration stated in the Articles of Incorporation. And that's because, you know, we're moving away from this term entity perspective. And I actually had hoped Jeff would be here to talk a little bit about that, because he was the one who was saying that he did more term entities. Nope, I did not have that in my notes, so I did not prepare to talk about that one.
I think all you were going to do, Valerie, was confirm that the articles or the certificate no longer requires duration, which I think is.
Yeah, that's what I said, is that because I think we're moving away from that on the certificate of formation. Does anybody feel strongly about leaving that in? I mean, we can circle back on Sean with that too, because that's going to be a form issue too, I think, once we start doing the new certificate of organization forms.
We don't have any concern about that because I don't think we get a lot of limited duration.
Yeah, I mean, I think
articles.
Jeff was the only one when we were talking about this before who had who formed on a regular basis limited term entities, I think for some real estate and bankruptcy stuff.
Mhm.
You know, which is I think the only context where I've ever seen them too. So,
Right.
so
The only
yes.
benefit of that, though, is that you don't have to go through the dissolution process at the end.
Right.
And, you know, we've kind of gone round and round about dissolution and what that looks like. So,
yeah, I mean, I'm fairly neutral on this because I think that, you know, it's nice to, for people who do it, they like to have that and they know how to do it. Michael, do you have any thoughts on this? Because you do a fair amount of real estate work too.
About the concept of fixed term
Yeah,
LLCs.
limited term LLCs.
I can think of maybe one or two instances in my whole career where I've done that.
Yeah.
And there were very specific, peculiar facts. And we could have gotten around it, you know, inside the operating agreement just as easily. So I
am inclined to recommend that we not adopt 6, just because we don't have it in the certificate, as we've talked about the certificate now. Does anybody feel strongly other than that? Okay.
I agree with you.
The only question that I have is what happens with the ones who do give a duration date
Currently?
beforehand? Yeah.
Currently, yeah, I think we're already thinking about having a phase in of, you know, because this is going to come in as 63A. It's not going to be 63. It's not going to be gutting stuff on 63. So there'll be a phase in of this and a phase out of the current. So the duration of the old entities will be respected, and we can find a way in the enabling legislation to make that work.
yeah, I think if we grandfather those that have a fixed duration,
Yeah,
that solves that problem.
yeah, and I think that's better for administrative purposes anyhow. One of these obnoxious things they tend to do with tax statutes is they make them effective like the year or the year after. And the problem is that then you are stuck with all of the warts of the new statute without a chance to fix them. So I'd much rather have a phase in anyhow over maybe 3 years, because I think that'll give chance to figure out if there are any issues. Okay. Okay, 708. And then moving on, 709 talks about reinstatement. And, you know, it basically is similar to our current statute at 63,654. Let me pull that up. Which is the reinstatement following administrative dissolution provisions. And basically says, and, you know, we need, I think the change that I would recommend is, you know, making the timelines consistent with what we did in 708, because the ROLCA has a period that it says basically 2 years after the date of dissolution. And I think a lot of folks have come to understand that it's 5 years under Oregon law, which is the current rule. And I don't think that prejudices against anyone's behavior, and it gives people who have an inadvertent dissolution more time to fix it, assuming someone doesn't camp on their name, which we've had happen.
Haven't we covered 709? I thought the only change we were going to make was A.
I thought we agreed 2 years was good.
Yeah, my notes say we agreed to stick with the 5 years.
I thought we were well, 708, I didn't think we did 709. I had my sticky on 708.
I have preliminary discussion of 709, and we discussed for a while, but nothing final.
Like in subsection A, we were going to add at the end of the brackets, or as otherwise established by rule or something to that effect.
Because the current Oregon law allows the secretary to, upon application of the LLC and it's showing, you know, good cause, essentially, that, you know, that it's back online, then the secretary can waive application of this rule for that LLC. And I thought, my understanding was that Ruth was maybe gonna try to look at a way to make sure that what we adopt is consistent with our current practice in that regard.
It's possible. So I have to be honest. So at the end of the last meeting, I was having a major allergy attack
Oh no.
and ended up going to urgent care immediately after this meeting. So it's possible we talked about this section. I just didn't write anything down.
I have the same,
So-
I actually have the same notes that Cody was just discussing.
Sorry.
It's okay.
Glad you're okay.
Yeah, high dose steroids will do that. But yeah, so okay, so somebody who is paying more attention to 7.9, what did we decide?
I think Cody's description was solid.
Okay,
Basically,
Cody, can you walk us through that again so I can actually write it down this time?
Sorry, sure. So on 709A, we stuck with the 5 years.
Mhm.
Okay. That's great.
Yeah.
And
that's what I have.
then there was, we had discussed this issue about how under the current Oregon statute, if the LLC asks and so that the Secretary of State can waive the application of this this rule that you've been if you've been administratively dissolved for the 5 years, then you're dead forever. And the Secretary of State can waive that if requested. And the LLC was active, it shows that it was active the whole time. And that was a 2011 change to our statute.
Okay, yeah.
And I thought that we had basically there was a general idea that that was fine, and that basically there was going to be some thought given to what tweak do we make to ROLCA to make that happen.
Oh, okay.
And I had thought that it might make sense that this change might be a tweak to C1.
C1.
Or something like that. That might be
I do have a note that we had that add sub 4 underneath C. And I think it's probably reasonable. It's probably enough for us to tell Sean that we want to incorporate sub 4 into
yeah,
this.
654 sub 4. Yeah, we were going to add that to this ROLCA section.
Yeah, so I think if we just tell Sean that we want that, he'll do that.
Okay, just simply do it that way.
Yeah, because it's because we have the process of what the Secretary of State goes through to figure out, okay, yes, it's reasonable to reinstate, right, upon petition, but 4 is kind of added on to that process in 63-64. So I think we can just add it on to our provisions. I don't think it's inconsistent with what they're saying here.
Great. And then does my notes also indicated with, maybe this is what I was thinking of with regard to C1 regarding the canceling the statement of administrative dissolution and doing a statement of reinstatement and filing that and serving a copy on the LLC. I can't remember. I thought Ruth had said maybe that's somewhat different from what our current practice is.
Right. So our current practice, we don't cancel the statement of administrative dissolution. What we do is prepare a statement of reinstatement when they go through the process. So Jamie, if you want to weigh in on this too, my preference would be to eliminate that first statement under C1 and start this with prepare a statement of reinstatement that states the Secretary of State's determination and effective date of reinstatement, because I think that would be closer to our actual practices.
Yeah.
Because it almost looks like two opposing things in the language here. We cancel the reinstatement and then we also do this other thing.
Yeah, I mean, is there any, because basically if you were to cancel the statement of administrative dissolution, you could, it would like stamp canceled on it. But I don't know what the value of that would be, just alone. So there's no
we
value
don't do
that
that
alone. Right.
And I might add that we do want it to show on the summary history, all the different transactions that businesses have with Secretary of State, if they have gone into administrative dissolution and if they have reinstated.
Right.
Because that's an important piece of information for the public to have, for a variety of reasons. I mean, you guys use the database, why you need to see that. So if we cancel administrative dissolution, that sort of leads me to believe that we would need to take that off of the summary history. And I don't, that doesn't seem like a logical step for us to take.
Yeah, that makes sense to me. And it's an easy enough fix. I'm sorry, what?
sorry, Jamie was going to weigh in, I think.
Oh, I was just going to agree. I don't think that we need to do the cancel. I think just the fact of reinstatement is enough.
Okay.
Okay.
And that's consistent with what we're doing now and what people understand.
Yeah.
Yeah, my notes also reflect that we talked last time about deleting the requirement in C2 to serve a copy on the LLC because that's something that you don't currently do.
Mhm.
Right. That was, I was coming to that. So
I have
yeah.
that.
That's reasonable. I mean, it's enough to put it on the website too for public notice.
And I
Right,
have
so-
that note as well.
And it's in the
Yeah.
file if someone wants to request the full file, but okay. Anything else that I was apparently hallucinating through? Sorry. Okay, good. I mean, I think that's fairly non-controversial. And then the only last section that we have in section 7 is judicial review of denial of reinstatement, which just provides a process for someone to review, appeal from Secretary of State's process, which I think is currently similar to what you guys have, right?
Yep.
I mean, it's 63-657 is virtually identical.
Yep. And we have one of those going on right now. So yeah.
Oh, really? Interesting.
Yeah, it's not an LLC.
Yeah, the only thing that's different between 63-657 and 710 is in sub B, they provide this not later than 30 days after the notice of denial. And so the way that it's set right now is we have the Secretary of State denies limited liabilities company's application for reinstatement following administrative dissolution. The Secretary of State shall give written notice to the limited liability company that explains the reason for denial. And then it says the limited liability company may appeal the denial of reinstatement provision, pursuant to the provisions of ORS Chapter 183. And I think that the reference to 183 is probably useful because it roadmaps for folks where they're supposed to go. And so I would suggest that maybe we should use that sub 2 language rather than the sub B language in 710. Just for our carpet layer sort of situation. Okay.
Say that part again, sorry.
Oh, just for the carpet layer situation, because current 63-657 sub 2 tells you that you have to look to ORS Chapter 183. In order to know what the process is to appeal the Secretary of State's denial of your application for reinstatement. So I think that's a useful thing to do. And so any of the timelines too would be consistent with other processes under there. And so that the only thing that I thought that, sub B added was it said, yes, you can appeal that and you have to do it within 30 days, but I'd rather have all the timelines be consistent with what people understand the timelines to be currently under 183. So I think that's a reasonable substitution.
So we're going with the administrative process under Chapter 183 instead of
Yeah.
having it be an appeal to the court. Because I thought we had talked a little bit last time about whether it would be cheaper for the Secretary of State to have that be an appeal to the court.
Right. I don't know admin law well enough, but I had understood from our prior discussion that the concept of judicial review is different from an Administrative Proceedings Act process, and that the Secretary of State was fine not doing the APA process anymore and instead doing the judicial review that ROLCA calls for.
Both processes are expensive for us. There's no way around it. Both processes involve us getting DOJ involved, our AAG. So I don't know that there are significant differences in cost.
So if under current Oregon law, someone goes through the administrative process, can they still get judicial review after that?
No, I believe that the administrative law judge's opinion is final.
No, you can appeal an ALJ's opinion.
I think you can. I think you can always get court review in the end.
Well, in that case, going with the ROLCA approach would eliminate that one step, right?
Yeah,
Let them go directly to judicial review.
Yeah, and my thought is that the informality of the Administrative Procedures Act rather than the formality of the judicial system is a better landing point for a lot of folks who are maybe not represented. We see this on the revenue side quite a lot, where having a conversation with someone at the agency first, who's not involved in the decision to, you know, deny them what they want, you know, who wasn't involved in that decision, can be useful because it provides that reality check of, hey, you know, here's the thing that you screwed up. So my preference,
usually, I'm sorry, Valerie, but usually on the revenue side, usually, at least at the federal level, they have a choice. They can go directly to the court, or they can go through an administrative process.
Right. But I think for the vast majority of taxpayers, the administrative process is their first port of call, because they've been having that conversation with the, you know, their auditor, and then the auditor's manager, and then appeals. I mean, I feel that there's value in the current process. You know, I understand that it doesn't lead to a lot of precedent too, which is maybe another issue. But I think there's also policy reasons why we have it currently set to go into the APA, the administrative procedure side of things, rather than the litigation side of things, to start with. And there is review of the, there is the possibility for review.
Valerie, I'd also point out that, just for sake of consistency with our entity acts, for example, Corporate Act 606572 really is the same language. Yeah. So I think if there was going to be a change in this appeal from denial of reinstatement, you know, it makes sense to be consistent across all the acts. And right now, that's where our legislature has landed in the entity acts. So I'd, you know, probably stay consistent for now. You know, as we look at the broader picture down the road, I'm sure it's an issue that we'll encounter again, and maybe make a different choice depending on how that discussion bears out.
Yeah, and there may be other things as you know, because I know we've had discussions before about the Corporate Act being the next port of call on this stuff. And there may be sort of overarching policy discussions to be had about that, that probably we should get someone from OJD involved into. Because I don't know what the current load on the court is, but from what I hear from Susan, it's pretty heavy. So
I think my understanding is that ALJ decisions are appealed to the Court of Appeals,
right.
Which is pretty heavily burdened. And I don't know if that's something we want to continue to send that direction.
Yeah, and so I think Michael's right. I mean, I think that, you know, there's policy decisions as far as, you know, ease of communication with our carpet layers, you know, burdens on the courts, costs associated with that, because I think it is cheaper for the state to run stuff through, even though DOJ has to get involved. You know, I think it's cheaper to go through the administrative process in general than it is to go to the courts. So, you know, so I think there's a lot of policy reasons reflected in that. And so my recommendation would be that we go with what's in the current statute for that sub B, as opposed to what Rolka says here about going directly to the courts.
I think that makes the most sense, because we're already going to have enough things to explain to the legislature when this bill is out there. Yeah. If we don't feel strongly about this particular issue, that there's a good reason to change it, I'm inclined to leave it the way it is.
Yeah, okay, that's my thought on it too. Anybody else have thoughts on this? Okay, good, excellent, thank you. And with that, we finish Article 7. Thank you for bearing with us on this. I'm sad that David is not here. He had a client emergency that he had to deal with, but you know, it's been a long haul through Article 7. So we're going on to Article 8, which we have Cody and Kyle, I believe, volunteered to talk about, or at least get us started on.
And Aurelia.
Okay, yep.
All right, 8. So this talks about actions by members. 801 covers members' direct action, which is a suit saying, I, as member, have been harmed by certain conduct. I'm going to sue about that. All the other parts of Article 8 talk about derivative actions, meaning that the shareholder, or in this case, the member, is not complaining about something that happened directly to them, but rather they're complaining about a cause of action that the company has and that the company should have brought in its own right, but it didn't do so. And so now the member is going to bring this claim on behalf of the company. So that's just want to throw out there just to set up the structure for what this article looks like.
And then Cody, is there a parallel in our current chapter 63?
There is, in part.
Okay.
63801 covers some issues that are addressed in Article 8, but it does not cover several issues that are in Article 8. For example, Section 801, which talks about direct actions by members, is not addressed in the Oregon statute. That's a matter of our common law. That's judicial decisions. 801A is consistent with Oregon law, and it essentially just talks about what is a direct action. A member may maintain a direct action against another member, a manager, or the LLC to enforce the member's rights and protect the member's interests, including rights and interests under the operating agreement or the act, or arising independently of the membership relationship. So that just is telling you you can sue people if they hurt you, right? That's not so interesting. What's interesting about 801 is 801B, which says a member maintaining a direct action under this section must plead and prove an actual or threatened injury that is not solely the result of an injury suffered or threatened to be suffered by the LLC. And the rationale being, if what you're complaining about is solely the result of an injury suffered by the LLC, then that's the LLC's claim to bring, and that would be a derivative action. So they're essentially just distinguishing what's a direct versus a derivative action, as I was discussing before. This subsection B actually has been, it's a change to Oregon law. For starters, just to throw that out there. Oregon law currently says that there's I'm going to quote a 1995 Oregon Court of Appeals decision. Oregon law prescribes a disjunctive test for direct actions. Minority shareholders may bring direct rather than derivative actions if they allege either harm to themselves distinct from the harm to the corporation, or a breach of a special duty owed by the defendant to the shareholders. And that defendant can be the other member, a manager, or the company itself. So this is a change, and the commentary to Rolka talks about how there's different courts that do different tests to differentiate direct from derivative claims. And the commentary talks about the special duty or special injury test that Oregon applies and that Delaware used to apply up until 2004, when Delaware got rid of the special duty, special injury concept. The Delaware court, in doing so, expressed its view that this was more just sort of a change in the language rather than any substantive change in how cases would come out. Academic commentary disagrees with that assessment, indicating that this actually essentially dooms in a variety of different scenarios claims that a plaintiff can bring that are doomed under the Rolka test, but that the plaintiff would be able to bring under the special injury test that Oregon has. And in fact, in the 1995 case that I described, Wolf against Mackey, the Court of Appeals of Oregon said, look, it's a disjunctive test. All you need is a breach of a special duty, and we have that here. So, therefore, this special injury test was applied, and that is what saved the shareholders' claim in that case. Given that this is a change in Oregon law, that there is a lot of states that don't follow the Rolka test, And in particular, also in terms of who is adopting ROLCA, Washington, California did not adopt this section, subsection B, nor did Alabama, Arizona, Illinois, or South Dakota. Florida modified this provision substantially. So that's like what, half the states or something that adopted ROLCA. That's a substantial portion. And so Kyle and Aurelia and I, our recommendation is essentially to modify this subsection B so that it codifies the Oregon test developed in the case law. And so it would basically be what we would have it read is a member maintaining a direct action under this section must plead and prove either, so I'm adding that word either, and then continuing on with the text that's already there, an actual or threatened injury that is, and then here, rather than not solely the result of, use the phrase distinct from an injury suffered or threatened to be suffered by the limited liability company, and then add at the end, or a breach of a contractual, fiduciary, or other special duty owed by the defendant to the member. And that comes from both that Wolf versus Mackey case, where they're saying, or a breach of a special duty owed by the defendant to the shareholders, because that was a corporate claim. But there's other cases, Lowen against Galligan from 1994. The court says, a special injury is established when there is a wrong suffered by the shareholder, not suffered by all shareholders generally, or where the wrong involves a contractual right of the shareholders, such as the right to vote. There's other Oregon cases as well that discuss the difference between direct and derivative claims, and the language I was just putting forth captures.
So, Cody, can you reread that, the language that you would add at the end? So I have or a breach.
Or, yeah, so at the end it would say, or a breach of a contractual, fiduciary, or other special duty owed by the defendant to the member.
I'd actually like to go back to A. How many does Delaware or Washington, have they adopted the ability for direct actions by a member?
They all allow direct actions.
Statutorily, is that right?
Washington and California didn't adopt at all Section 701.
Mm-hmm.
They just don't have it. And you might not need 701, but
wait, 701 or 801?
Oh, 801, I apologize, 801. Washington, California didn't adopt 801 at all. And then several other states adopted A, but not B, under 801. And so we could just not adopt 801 at all and just leave it to the case law as we currently have it in Oregon. The only part of that and that would be in a sense a fine way to go, but the only part that then would be an issue is when we go back at the end of this, going through Article 8, and we have to look at Section 105 again. 105C11 talks about how the operating agreement can modify your ability to bring actions under Article 8.
Right.
And maybe we say that the operating agreement could modify how you bring derivative actions under Article 8, and therefore not allow people to make any changes to direct actions in their operating agreement. But I assumed that there would be people wanting to have the ability to make some changes to the direct actions as well as derivative. And then it seemed the better way to do that was to modify, to keep 801 in and just have it be reflective of our current law.
I mean, is there any harm in, because I mean, I think it's intuitive, right? That you should be able to bring a direct action. And I think the reason for the derivative statute is because it's maybe less intuitive that you would be able to do this. Is there any harm in having explicit the ability to bring a direct action?
Everybody has the ability, every state has the ability to bring a direct action. Right. Whether they do that, whether they codify that or whether it's just part of common law, they all have it.
Right.
So it's not a question of whether we should have it or not, or I don't even think it's really a question of whether we should make it explicit or not in terms of, you know, again, codifying it, because it's going to exist. It does exist. There's no change to that under any of the states and how they've treated this. The question is if you don't adopt 801 at all, such that it's purely common law, then when you get to 105 and you start talking about how the actions by members be tinkered with or not in the operating agreement,
Right.
then if you haven't adopted 801, then you're effectively saying there can, or I don't know, it would be a much more difficult drafting job to say, how could you modify through your operating agreement a direct action if direct actions are never discussed in the act at all?
Does the language in 801A restrict our current understanding of what a direct action can look like? With the exception of the language that you suggested for B, but with respect to A, I mean, does that put any additional limitations on the types of direct actions that can be brought?
No, I mean, you know, I didn't read it, but you know, the beginning of A says subject to subsection B, you can bring a direct action when you've gotten hurt,
right.
Essentially. And so that just sort of begs the question under B. I don't think adopting A by itself adds value.
Okay.
I mean, I just don't think that because it begs the question, well, when have you been harmed distinctly from the company?
I think Cody is a very good advocate, and he's completely convinced me.
Oh, I don't mean to convince.
But really, so I think our premise when we started on this project was that sort of our first thought was, let's see if we can adopt all of this, and then we'll modify it to the extent that is appropriate when we have Oregon law that conflicts. And I think that amending B is entirely appropriate, both because of Oregon law and also because of our concerns about the carpet layers. I mean, if the carpet layer says, oh, I'm just going to bring a suit because, you know, this is wrong, and then they don't also bring a derivative suit, they just bring a direct action, and then the court could throw it out saying, oh, this isn't appropriate. So I think this is a really good solution.
I actually prefer to just delete the section. I mean, frankly, it's kind of news to me that our law allows direct actions against members of the LLC, and having it statutorily in there.
Actually, I'm going to advocate for the opposite point of view, which is I think we should have section 801A there, even if it doesn't add much to Oregon law, because I know oftentimes we are dealing with judges whose primary expertise is in areas of criminal law or family law. And sometimes it can just be very helpful to point them to a statute that says, look, we can bring this action here. Right here is where it says you can do that.
Yeah.
Even though there's case law that already says that, you could cite 6 cases that say that. It's sometimes very helpful to have a statute you can just simply point to. And if it's not a change in Oregon law, and I don't think 801A is a change in Oregon law, then I think it's very useful to have it there specifically for that purpose.
Just makes it clearer.
Yeah, I don't think you can have A without B.
Personal liability if they become a member of an LLC. They could be
Cliff, it's an action that a member brings against another member. It's not an action that, and so I think that the addition that Cody's proposing with respect to B, with respect to fiduciary breach and, other things that they've already agreed to, it's effectively a contract action against the other members, is how I'm reading your proposed amendment.
But that also could be handled through a derivative action as opposed to you get
right. But Cliff, these direct actions are things like the LLC is supposed to pay a distribution on December 31st to member A, and they don't do it. They're supposed to, and they don't. So member A can sue the LLC and say, hey, give me my distribution. I'm entitled to it. That's all this is. We're talking about direct actions for.
The way I read this is you're suing other members. You're not suing the LLC. So you're
Right,
gonna
but maybe
make a lot of
you're
risk
suing the other
liability.
member that's managing it, saying, hey, you're supposed to make the company give me my distribution, and you're not.
And why
And
can't
that's a fair lawsuit.
why
We've always
can't
been
that be
able to do
handled-
that.
Why can't that be handled against the LLC and not the individual member?
I think the thing is that, you know, we can already do this under Oregon law. You know, and so all that this is doing, and I think all that Kyle, Cody, and Aurelia are saying this is doing is codifying what is already current Oregon law. You know, I get what you're saying, and that we want to preserve the wall, right?
Liability shield. Yeah.
Yeah, but to the extent that there's no wall there anyhow, we're not preserving anything by striking 801. Michael, you look like you want to say something.
Valerie, I think from a substantive standpoint, I'm inclined to go with Cody's suggestion. Administratively, I'd like to be able to, number one, see the text of his proposed language. The words went by quickly. And number two, Cody, maybe you can throw out some of the some cites to some of the cases you mentioned, just for us to take a quick look and come back around to it next time and just button this up. Again, I think Teresa, you mentioned that just the ability to show a judge here, it's in the statute. We can bring this direct action rather than, you know, a litany of common law cases. Seems to be consistent with, you know, entity acts being codified rather than creatures of common law.
Cody, would you mind putting that language in the chat if it's not too much trouble?
Yeah, I was just trying to do that. I have, yeah, I'll put the language in the chat. It just, when I was trying to do it right now, it wasn't having like the bolding and the, you know, stuff that I had done underlining to have it show the changes that I'm making, but I'm going to put it in the chat now anyway, so people can see.
James has a good question. So Aurelia, Cody, Kyle, do any of you represent defendants?
Yeah, I mean, I think, well, I have a practice that represents both plaintiffs and defendants, depending upon.
But primarily, I mean, do we have
in
anybody
these kinds
who's
of
like
cases,
a member of OAD?
I do tend to plaintiff them more often. Yeah.
Yeah, I mean, it depends a little bit. Sometimes these business breakups, it depends on sort of who gets to the courthouse first. But yeah, I'd say probably more plaintiff side, but I've certainly represented a lot of defendants as well.
Yeah, that's pretty.
I'm just wondering if we had someone like OAD, someone who's a member of OADC for.
Wilson, what did you just put in the chat?
I was trying to raise a couple of points. One of them is there's a cross reference to 801 and 409. And I was trying to copy and paste that cross reference in 409 to 801. But essentially, 409 says that subject to 801, members in a member managed LLC have a fiduciary duty of loyalty and care that's owed to their fellow members. Essentially giving a member the ability to sue their fellow members for a breach of loyalty or care in a direct action subject to 801. So what we say in 801 will have implications for the ability of a member to sue another member or to sue a manager in their individual capacity for breach of fiduciary duty.
Yeah, just to be clear, it's not just purely contract claims that a member can bring against another member. There's breach of fiduciary duty claims as well. That's where
I start to get worried about this section, is because I think the contract claims can be treated like contract claims in many respects, and courts are familiar with that. It's the fiduciary duty claims that get a little bit more squishy, and as a defendant, I get to be a little bit more worried.
Right. And James, to your point, I think Mohsen sort of represents the defendant perspective on these views.
I think I managed to clip this stuff into the chat, maybe. That's what Mohsen meant.
What?
Well, so you know, on this point of, you know, whether claims should be allowed to be brought at all, you know, I think all 50 states, I mean, they're all allowing direct claims to be brought, and they're all allowing it to be brought essentially when the harm to the plaintiff is distinct from the harm to the company. but then there's this question of you know, how do you define what makes it different? So if the, you know, as we've already gone through in our discussion of Article 4, each member owes each other fiduciary duties. So if one member steals from the company just generally, then that is the question: is have they only harmed the company, or have they also harmed their fellow member who you know, they owe fiduciary duties to? And that, you know, or what other things can they do? You know, if they are usurping other opportunities for the company, if they are squeezing out their fellow member, maybe they are as manager or as the, you know, the managing member, maybe they are taking certain actions to reduce cash inflow to the company, knowing that they have their own personal means to handle that, but all of a sudden there aren't distributions being made to the minority owner who relies on that income. And then they try to do that as part of a scheme to buy out the minority member at a reduced price. And then as soon as that buyout has occurred, then they can just start taking all the money for themselves that they've sort of been, you know, falsely hindering the ability of the company to be having full value, things like that. And if you're doing that and you're harming your partner directly, even if you're not harming the company will ultimately have its full value, but you're doing it to harm your partner, then that is the kind of thing that, you know, under Oregon law is a direct claim. It's when you're breaching that fiduciary duty owed to your partner, fellow member.
Cody, what's the value in, so I take your proposal to be essentially to codify the existing common law distinction between direct and derivative claims, which makes sense, but what is the value in codifying that distinction rather than just leaving it to the courts to articulate, in particular in light of the fact that the Delaware courts have evolved their distinction away from what Oregon currently does to a new test, and Oregon courts may one day want to go in the same direction, but if we ossify it into a statute, they will be precluded from doing so.
I'm fine. Ultimately, I'm fine just dropping 801 and just leaving it to the common law. I mean, you know, first of all, I just want to make clear that everything I'll be saying about Article 8 is after talking with Aurelia and Kyle. So this was our sort of joint thoughts about Article 8. My own thoughts, so this isn't what I've run by Aurelia and Kyle, is I'm fine dropping 801. As a drafting matter, I think what that means is that, you know, when we get to section 105, it'll mean that the operating agreement won't have the ability to limit direct actions, which, you know, I'm fine with. But I imagine you may not want that result either. So I guess, you know, maybe you come up with the creative drafting solution to that, but I hadn't thought of a good one.
Kyle, how do you feel about this?
Yeah, I'd be comfortable dropping it as well, I think. Obviously, that 105 issue is the main issue about whether you include this or not.
I think we ought to include it though, because it is useful for people to know what the law is. Mm-hmm. And it is useful to have that be accessible to the public. And I don't just mean the carpet laters, but the people who dabble in LLCs, who form one or two a year, as opposed to folks on this call who form them all the time. And I think it's very helpful to have clear rules. And I appreciate that the law likes to evolve, but every time the law changes the standard like that, somebody gets surprised. Right. And that's not always really fair to people, to have them be sort of the victim of being the one case where the court decides to change the rule on everybody. That's hard on people. And I think it's more valuable to have clarity in the law. And if Oregon decides it wants to change its standard to something more like what Delaware has done, or more like what is reflected in subsection B as drafted by Rolka, then they can talk about it and do it in the sunshine and do it in a way that people will know in advance that's what is going to happen so that they can plan accordingly. But it's not fair to surprise people with changes in the law, which is what happens when courts decide to suddenly morph the rules in the middle of the game, like Delaware did to whoever these poor people were when it changed its rule. And it may be the better rule, but
Teresa, if we leave it out, we aren't changing it. We're literally stating with status quo, to your point. Cody, where in section 105 was
Yeah,
the
Cliff,
reference?
I think Cliff,
B11.
before we move on, I think Teresa's point wasn't just that you know, it is not a change in the law. I don't think that was her only point. I think the point was clarity, right? I mean, I think the point is that it's for the people who don't do this all the time, that they have a place where it says, yes, you can do this.
But
So
let me give you an example of why that matters.
yeah,
because right now what this statute says is a member may maintain a direct action. So then the question becomes, what do you do with the case? And I have a case like this right now where a creditor is trying to do that. And the creditor doesn't have the right to maintain the action. They don't have any right at all to maintain that action. But, you know, everybody's looking around at case law, and is there something we can point to that says who can do this and who can't do it? It would sure be nice if we had clarity. It's not under this particular act, it's under one of the other entity acts. But it's one of these issues where there are real advantages to having clarity, because you can dismiss claims more easily when there's clarity than you can when, well, there's a bunch of case law, but the case law doesn't preclude anything. It doesn't say who can bring that claim. It just says what that claim can look like. So, I mean, I think there are advantages to keeping 801. I think it's a separate question of whether we should change the standard under B or keep what Oregon has. And I'm prepared to accept the recommendation that Cody, Aurelia, and Kyle have of changing it to keep what's existing Oregon law. But I think dumping it all together will, it's not a law improvement. What we're trying to do is make the law clearer for people. And I think that is useful in and of itself.
yeah, and I think Roberta's point earlier was that, you know, we had a policy decision that we were going to generally stick with ROLCA, except where there were compelling reasons to diverge. You know, and I think we've identified a number of those, but I don't know that this is one of them. I mean, Cliff, I understand where you're coming from when you say that we need to preserve that wall, but I don't know that, at least from my perspective, I haven't heard a compelling reason to diverge from ROLCA.
Valerie, can I bring some? This is one of these I always listen in the background and try to think of the political implications. I'm
You're not just playing solitaire on your computer?
No, I listen. I promise. I do worry that this could be an area that we could face some serious backlash from lobbyists. Just, and it doesn't mean, and I want to be very clear, it doesn't mean we shouldn't do it, but I do feel it's my job to kind of consider the political implications.
Yeah.
I do think listening to my heart might be in one place, but I also want to make sure that on behalf of the commission that we're presenting a bill that has a chance to pass. And I don't know, again, Susan, we don't have a member from the bar here right now, et cetera, but this is one of these areas that I just want to make sure that we are careful with, because even if it is, and I was listening, everything that Cody and Teresa and folks have argued about the fact that this is already available through the common law, I'm certain that's true. But I do think that that certain folks in the business community will see this as a pretty remarkable change. So that's just something we should talk about.
I think that's a reasonable point. And what I would suggest is that I suggest we take a look at some of those cases that Cody dropped into the chat. Sandy emailed them to all of you, so you should have both the proposed language and the citations to the cases. I would like John's perspective on this as well, because John very differently has a different political perspective than I do, and that Susan does, right? And so he's going to have a counterbalancing perspective on what his constituency would feel and the political realities of it. So what I would propose, Cody, is that we take a look at what you've dropped into the chat. It looks like there's some additional language that got dropped into the chat. Sandy, can you please forward that also to the group?
Yeah, definitely. Roberta's comment, and then we have more from Cody. Yeah,
I don't think mine is not very important. I mean, it's already in ROLCA, but I do want to just point out something that I think Teresa was saying, that we have case law and that's great, but when there are gray areas, I mean, a single judge can change case law, precedent notwithstanding. Whereas if we have it in a statute that's clear, it's not that easy to do. And I don't know if that's kind of what you were getting at, Teresa, but that's sort of what I heard.
Yeah, I mean, I don't disagree with what either of you are saying, and I don't disagree with what Cliff is saying. But I think that we probably should think about this and probably should talk to the folks who are more politically savvy than I am. And because I think we have made this decision that we're going to try and stick with ROLCA, and this is part of ROLCA. It is part of the current common law. So it seems to me that the two should march together and towards adoption. But if it's going to be a huge issue, then at least we want to be able to address the response to it if there's going to be a response. Does that sound reasonable, Cody?
Yeah. So the action plan is that, I mean, it would make sense. For example, I would think that Cliff and James, for example, you've got folks at your firm who, regularly defend these kinds of claims. You might talk to, John, for example, or other folks at your firms who are the litigator side. And I think that that'll more fully vet this with the defense bar. Essentially, those are the kind of people who, might advocate for a different solution.
Yeah, and John was wondering when he should re-engage. So this is a good opportunity for John to re-engage. Okay, so
I also just want to throw out that we all want something that'll get through, and I know that the corporate interest is a strong lobbying interest, but so is the trial lawyers and so forth. So we'll want to make sure that we steer something that doesn't get hit by Scylla or Charybdis here.
I'm sure they'd appreciate the metaphor there for comparison. So Cliff and James, would you mind talking to the folks in your office? Cliff, can you talk to John, please?
Yep.
And just get their takes on this. I mean, I'm neutral-ish, leaning towards adoption, just because I think if it's what we have, it's what we have, and from the policy perspective, they can always go in and fix it later. But I do want to know what the issues are likely to be on adoption. And then Sandy, can you please reach out to Susan? He's on the phone.
Should we move on to 802?
Yeah, let's move on to 802.
802 is consistent with current Oregon law, which is 63801 sub 2. A member may maintain a derivative action to enforce a right of a limited liability company if, one, the member first makes a demand on the other members in a member-managed LLC or the managers in a manager-managed LLC, requesting that they cause the company to bring an action to enforce the right, and the managers or other members do not bring the action within a reasonable time, or if a demand under paragraph 1 would be futile. That is same as what 63801 sub 2 says. So we think that 802 should just be adopted.
Okay.
I'm happy to pause if people want to talk about it, but if everyone agrees, I'll just move on to 803.
And I feel like this is an opportunity for us to introduce a Star Trek reference, but I'll resist.
803 talks about who is a proper plaintiff to bring a derivative action. This is also fine and consistent with Oregon law. A derivative action to enforce a right of a limited liability company may be maintained only by a person that is a member at the time the action is commenced and was a member when the conduct giving rise to the action occurred, or whose status as a member devolved on them by operation of law or pursuant to the terms of the operating agreement from a member who was a member at the time of the conduct. And that is similar to ORS 63801 as well. no, strike that. I didn't mean to
No,
say
it's not
it's
in there.
801.1. That's the provision I'm looking for.
Yeah.
And so we think that this should be adopted as well.
I mean, it seems almost more clear from a drafting perspective than 801 sub 1 is, to me anyhow.
Yeah.
Just because it has a positive right as opposed to all the like negatives. I'm fine with that. Anybody have any questions or concerns?
All right, marching on to 804. Pleading.
Cody, I'm curious. What have other states done with, like, what has Delaware and Washington done with those? I don't know if it really makes a difference to whether I go one way or the other, but.
My memory is that they had adopted them, or most other states have been adopting them. These provisions are also generally reflected in the common law before these things got codified as well. But I'm happy to double check on Washington here, for example.
Yeah, I think since we're going to be revisiting 801 next time, maybe just an overview of what Washington's doing on the derivative proceedings would be helpful.
I'm not objecting to 802, but the language doesn't look to me to be quite exactly the same as.
Well, the construction's different, right?
Yeah.
And that's what I was saying about the construction with sub 1 is different from 802, in that I think it's a more clear way to state it than 801 sub 1. I don't know that it captures different people though. Because we have when the person has to be a member when the transaction complained of occurred, right? Or who became a member through operation of law. Task members in operation of law or pursuant to the terms of the operating. I guess the terms of the operating agreement is different, but that seems logical to me, right?
Yeah, but I actually was looking at 802. I know we moved past that already, but I'm still confused about it.
Okay.
Sure. So, yeah, go ahead. What about it?
Okay, I thought what you said was that 802 was the same as 63.801 paragraph 2. And maybe that's not what you said, but it doesn't look the same to me.
I think the difference here is that whereas 863.801.2 says that you have to allege with particularity in your complaint that you have done this and describes what you must do. And I think ROLCA section 802 says this is just what you must do, but it doesn't also say you must allege it with particularity in your complaint.
That particularity requirement is in ROLCA 804, which we're about to get to.
So maybe we don't really have a difference. It's just split it into different places.
Right. Well, so when you look at what 802 talks about, it talks about how you have to make a demand and give them a reasonable time to basically bring the claim on their own behalf or not do so. And the alternative to making that demand is you can say that you don't have to make a demand if it would be futile. And when you look at 63.801.2, it talks about how you have to do a demand made, if any, to obtain action by the managers or members who would otherwise have the authority to have the LLC do it in its own right. And either the demand was refused or ignored, or the reason why a demand was not made. And futility being the reason why you're allowed to not make a demand. And so that part is the same. With regard to the particularity aspect, 804 says in a derivative action, the complaint must state with particularity the date and content of plaintiff's demand and the response to the demand by the managers or other members, or why demand should be excused as futile. And so that captures that sort of beginning part of 801 sub 2. And of course, 801 sub 2 also has the part about how you can modify this in your operating agreement, but under ROLCA, that's all covered in 105.
Okay, thank you. I just was looking at the two things. I'm like, wait, this does not look the same to me. So yeah. I appreciate that explanation. Thanks.
Yeah, you bet. And Washington adopted 802, 803, and 804. as is. And so having just described 804, which is also consistent with Oregon law, our thought is to adopt 804 as well. Is everyone cool with that? I mean, I'll slow down. Sorry, I'm going too fast. When I see areas where I think that there might be unanimous agreement, then I tend to go faster.
Yeah, well, the requirements are the same in 804 as under current Oregon law, right?
That's correct.
I'm fine with that. Anybody have any questions or concerns? All right.
Okay, so that concludes our discussion of the fly through, quick, easy ones. Everything else is going to be more complicated.
Okay.
So 805, it talks about this concept of a special litigation committee, which does not exist under current Oregon law. And it says if a LLC is named as a party in a derivative proceeding, the company can appoint a special litigation committee to investigate the claims, determine whether pursuing those claims is the best interest of the company. And then once they've done that, if they've appointed that special litigation committee, then they can seek to stay discovery in the case for the time necessary for the committee to make its investigation. Then there's ultimately, and then I'll get back to what 805 B and C talk about, but then D, if the committee ends up deciding after its investigation that it is in the best interest of the LLC to continue the case, then they can let the plaintiff bring that case, which almost never happens. They can continue the case under the control of the committee. They can settle the case, or they can get the case dismissed, depending upon what they decide to do. The reality is the vast bulk of the time when a SLC is formed, the ultimate decision is to not have any such claim be brought. And in the rare instance when a claim is brought, then the SLC almost always decides that it or the company should bring the claim, not the plaintiff. And it's like, 1 in a million when they say, oh yeah, the plaintiff should be the one to bring the claim. Because it's such a powerful tool, the formation of this SLC can often result in the death of the case, as well as this long stays while the SLC investigates and so forth. There are some restrictions placed on the SLC, and this is in 805B, that the SLC has to be composed of one or more disinterested and independent individuals who may be members. Under C, the SLC may be appointed by the affirmative vote or consent of a majority of the members not named as parties in the proceeding, or if all the members are named as parties, then by a majority of those defendants. And sort of similar if managers are the ones being sued. So there, and there is this requirement that the SLC's investigation be appropriate. And courts have fleshed out what some of those terms mean. If the court finds that the members of the committee were disinterested, and now I'm quoting from E, the court shall determine whether the members of the committee were disinterested and independent, and whether the committee conducted its investigation and made its recommendation in good faith, independently with reasonable care, with the committee having the burden of proof. And if the court finds all of that was true, then the court shall enforce the determination of the committee. Otherwise, the court shall dissolve the stay of discovery and allow the action to continue under the control of the plaintiff. So that's how the SLC works. Like I say, this is not provided for in Oregon law. The closest Oregon law comes to this is in 801 sub 2, the last sentence, whether or not a demand for action was made. If the limited liability company commences an investigation of the charges made in the demand or complaint, the court may stay any proceeding until the investigation is completed. Which, is, of course, the court can do that anyway. That's sort of an inherent power, but it's statutory under current Oregon law. And under Oregon practice, these investigations basically never happen. It's very rare that these kinds of investigations happen. So such that stay authority is very rarely exercised. And I'll throw out that Washington and California did not adopt Section 805, nor did Alabama, Iowa, or Illinois. And I'll also throw out, with regard to Section 105C12, that's saying that the operating agreement may not vary the provisions of Section 805, but the operating agreement may provide that the company may not have a special litigation committee. So essentially saying that the operating agreement can effectively write out 805 by saying there is no such thing as a special litigation committee. But if the operating agreement is going to allow a special litigation committee to be formed, then it can't change 805. And so Washington, California, and those other states that didn't adopt 805, they also did not adopt 105C12 on the thought of, we just don't want SLCs at all. There's also academic commentary that indicates that SLCs, which are, they're primarily designed as a way to put an end to derivative actions brought by plaintiffs. But that because the courts have been at least some courts have been really rigorous in enforcing all of these requirements of independence, good faith, rigorousness of investigation, and so forth, that actually companies can sometimes have a hard time getting the court to approve what their SLC did in the end, and that sometimes these SLCs don't actually help the company in the end very much. That's one way of viewing it. I think that the massive stay of discovery and just in general of the lawsuit is itself a win when that happens. But so, given that so many states have not adopted this and that this is a change to Oregon law, and also just for the additional policy reason that if a demand was made, the company already had a chance to investigate the claim before the suit was filed and already made its decision. And alternatively, if demand was futile, then in the court, and always in these cases, when just as a context, our recommendation is to not adopt 805. When the plaintiff pleads futility, this is independent of any special litigation committee. When the plaintiff pleads that demand on the company before filing suit was futile, that almost always is challenged in a motion to dismiss by the defendant saying, no, it's not futile. We have enough people on our board or here managers or members who are disinterested and would have given a fair view of this complaint and found that it was not worth bringing. And so therefore you should have made demand, plaintiff, it wasn't futile. And so that always is coming along. And so the court is going to analyze that issue early in any derivative claim. And if the court says, no, I think that demand was futile, then essentially what they're saying is that the company's managers or the people in charge running the company are essentially biased. They're implicated by what the claims are about. And in that circumstance, again, it's going to be really hard for the company ever to come up with an SLC that passes muster. And so, why have this company with these implicated members for whom demand in the first place was futile, why have them give this sort of additional opportunity to slow down the litigation and potentially squash it and through the form of an SLC? So those are sort of the reasons why we suggest not adopting 805.
Have any states adopted 805?
Yeah, some have. For example, Idaho, which is
I mean, they basically adopted everything though, right?
just carte blanche
Yeah.
adopted Volca. That probably was a 5-minute committee hearing.
Yeah.
But in any event, so yes, some states have adopted 805, but several states, including Washington and California, did not adopt it. Also Iowa, Illinois, and Alabama.
Do we know what Delaware?
Cody, if you're talking about how they are used and how they're rarely, how they're often used for X, Y, or Z, where does that come from? Are there many states that have adopted it besides?
Well, Delaware has a form of the SLC, and that's probably where the vast bulk of all corporate law comes out of Delaware, but the bulk of the SLC law comes out of Delaware. Yeah, I mean, and in part that's also the reality. FLIR just sold, in the last week or what have you, and they converted last year from an Oregon company to a Delaware company, and that was at a time where I was actually working on a claim, a case against FLIR, and that ended up kicking the case out to Delaware rather than here in Oregon because of them switching to Delaware and having under a Delaware law, they can have a forum selection clause. But it seems like that was less about the lawsuit that I was working on and much more about their plans to sell their company. But the reality is these SLCs, it can be expensive and time consuming, but it's the kind of thing that big companies tend to do. And those big companies tend to be Delaware companies.
Cliff, any thoughts?
No, I like Cody's recommendation to leave it out.
Okay. Teresa, you looked like you were going to say something earlier. Has your question been addressed? Your thought been addressed?
I wasn't going to say something earlier, but I agree with Cody's recommendation. This seems to me like something you want for big, giant multinational companies, which is just not the bulk of what we do out here in Oregon. It seems like it would be way too much freight for your small business dispute, which is a lot of what I think we have. And I worry that it would be used as a litigation tactic to stay discovery and stop meritorious cases, as opposed to something that is really intended to solve problems.
Okay, so
Cody, just a quick question, Valerie. This doesn't exist in any of Oregon's other entity acts, correct?
Don't believe it does.
Okay. I just took a quick look at chapter 60. I don't see, it talks about committees, but nothing like this.
And I didn't look beyond the Corporation Act.
I would be hesitant to add this procedure that's not consistent across the entity lines. And I think that's a question for the legislature. If they wanted to add this, it should be added across all entities, in my opinion anyway.
Yeah, well, that makes sense to me. Is there value though in keeping the language about the court stay may stay any proceeding until the investigation is completed, or is that automatically part of the process? I think you already.
It's fine. I think if we had, if our 805 just included that sentence that's in 63-801-2 about, if they commence so in other words, it's no change to Oregon law, that's fine. And some states that didn't adopt 805, they do have a statutory text similar to what we currently have in Oregon law. We could, in essence, we could, not adopt 805, but just sort of have our 805 be equivalent to that last sentence of 63-801-2.
Yeah, because it sounded to me, based on what you were saying, that occasionally that process is used. Not frequently, and it would be subject to all the other, court rules that apply. But to the extent that people are using it, I hate to take away a tool.
Yeah. And, I don't, in my own view, the ability of the court to stay a case when there's this investigation that occurs is an inherent authority of the court. It doesn't need a statute to give the court that authority, but it's harmless to have the statute, and it makes it clear that, our decision on this is to stick with Oregon law.
Yeah.
I think
Cody, I
that
like
makes a
your
lot of
suggestion.
sense.
Sorry,
I was just going to say, if we do that, which I think makes sense, we just need to clean up the cross-reference in section 105C12.
Yeah, no, absolutely. Yeah, I think
Yes.
they basically would get rid of 105C12 still, right?
Yeah, I think you
Correct.
would, because you wouldn't vary that. It would just be
Right.
a permissive power of the court.
Right.
There wouldn't really be a need to vary it. And sorry, Michael, I didn't mean to talk over you.
I was just concurring with Cody's suggestion of adding that last sentence of 801 sub 2 in ORS.
Yeah.
Okay, so the thought is to have, our 805 only just say what that last sentence of 801 sub 2 is, and we'll delete 105C12.
Yeah. That's what I think is the practical answer.
Okay, that sounds fine.
So
all right.
that last sentence that we're talking about is the one that the court can investigate? Is that the one?
Well, it says whether or not a demand for action was
Right.
made. If the limited liability company commences an investigation of the charges made in the demand or complaint, the court may stay any proceeding until the investigation is completed. And
Okay.
I think we'll have to modify it to make, that the sentence standing alone, we'll have to talk about derivative
Right.
proceeding.
So just taking out the special litigation vehicle.
Yeah. Would you guys, Kyle and Cody and Aurelia, mind suggesting just some language that we can bring to Sean?
Yeah, I think if we just say whether or not a demand for action was made in a derivative proceeding, if the limited liability company commences an investigation of the charges made in the demand or complaint, the court may stay any proceeding until the investigation is complete. I think just adding in a derivative proceeding before the comma would be sufficient.
Yeah.
I think we need a new title for the provision too, the current.
Yeah, we can just call it stay.
Process or something.
Sounds
I'm
like
sure
we're
that-
dog training.
Yeah. I'm sure Sean will have thoughts about that. Okay. Anything else on this section? My goodness, you guys are gonna set a record. Why don't we take a short break, give people a chance to get more coffee and use the restroom and everything, come back in about, I don't know, come back at 10:40?
Okay.
Good, I'm gonna stop the recording right now.
So 806A is consistent with current Oregon law. Not that this is codified in Oregon, but it also just follows naturally from the concept of what is a derivative action, meaning, that's an action that is about the corporation or the company's rights. So any proceeds or other benefits of a derivative action, whether by judgment, compromise, or settlement, belong to the LLC and not to the plaintiff. So that's your money damages is going to go to the company, not the plaintiff. And if the plaintiff being a member, maybe there's a distribution after that or something, and the plaintiff shares in that distribution, then that all makes sense. And if the plaintiff receives any proceeds, the plaintiff shall remit them immediately to the company. That also makes sense. B, so we recommend adopt A as is. B, if a derivative action is successful in whole or in part, the court may award the plaintiff reasonable expenses, including reasonable attorney fees and costs from the recovery of the limited liability company. That's essentially the same as Oregon law right now. We don't have it codified, but under the common fund doctrine for awarding attorney fees, if I go out and bring a lawsuit and that creates a common fund that benefits not just me, but other people as well, here, all of the members of the LLC, then I get my attorney fees in that case. This is similar also to, for example, the PERS cases where one public employee brings a PERS case and then the court rules in favor of the employees and against the state. And therefore, all the employees of the state get money because of this one plaintiff's efforts. and the court holds that sort of out of that fund, then the plaintiff gets their attorney fees paid for. So the aspect of attorney fees isn't a change in Oregon law. The part of ROLCA that is a change in Oregon law is that when they talk about reasonable expenses, including attorney's fees and costs, that expenses and that including indicates that you also get expert fees, which you currently don't get under Oregon law. But we think that that makes sense to have as a change. And because of the quirky nature of Oregon law regarding, they kind of require you to have magic words if you want to allow costs beyond those contemplated by ORCP 68. We recommend adding explicitly, expert fees after attorney fees to make it clear that we're not only talking about ORCP 68 costs, but we're also talking about your other expenses, because that's the point of the ROLCA change there. And so we had recommend adopting 806B, but just adding expert fees after attorney fees so that we can get past this magic words requirement of Oregon law.
Cody, just for my own.
That would be broadening. That would be broadening what's there today.
Yeah, right now under Oregon law, there's no right to expert fees in derivative cases. You have only the right to attorney fees and costs. And costs as defined by ORCP 68.
I would assume the defense bar would similar to what we discussed on 801, I assume they would not favor.
That might be so. That might be so.
I would clarify.
Doesn't seem unreasonable to me, just putting that out there, but
I appreciate
that may be.
And I'm fine to have that be something that, along with 801, when John and other people, from the sort of more thoroughly defense bar look at this, have them look at that issue as well. Go ahead, Aurelia.
I was just gonna say, I don't know that it's inconsistent with Oregon law. There's no case law awarding expert fees in derivative cases, but I think there's an argument that can be made based on the common fund doctrine that they could be included in that. We don't have a ruling on that specifically.
Yeah, that's a better statement of the current Oregon law.
Just because I do think it is a change, I would like to get John's thoughts on it and Susan's thoughts on it. So and James, also your lobbyist, I'd be curious to hear what they think about it. So to the extent that they're already looking at the 801 issue, could you please also ask them about this issue? But I think with Aurelia's caveat, which is, I think, important in that, there is this common fund doctrine that's out there right now that, it possibly admits for those anyhow.
Cody, just for my own education, if somebody brings a derivative action against a party on behalf of the company, who's picking up those law fees or the attorney fees?
Who pays them?
Yeah.
The company does. And so, keep in mind that the company pays, because actually, no, the company doesn't pay the fees. The defendant, whoever is found to have been in the wrong.
Well, but leading up to the time when there's actually determination, wouldn't those be picked up by a member or?
Oh, who's paying it as the case goes along?
Yeah.
Oh, sorry. Generally, these are done on a contingency fee basis, and the plaintiff member, that minority member, generally is paying, they're paying for it through their contingency fee lawyer. And that's how it goes along up until, you get to judgment or what have you. And that point, you would get an award of attorney fees against the defendant who is found liable in favor of that minority member plaintiff who brought the case.
So does this then basically prevent that member who brought the derivative claim from ever recovering his attorney's fees? And what I'm doing, just so you know, is I'm comparing it to 181004 of the Delaware, which provides for expenses, and it's much more general statute that just provides for recovery of reasonable expenses, including reasonable attorney's fees. And so I'm just wondering if we need this statute as it stands to specifically state that everything goes to the company, which means it kind of, in my mind, prevents or is a reason that somebody wouldn't bring a derivative claim, because they could be on the hook for all the expenses without any chance of recovering them.
Right. So the way it works is that the plaintiff, that member of the company who's bringing the derivative claim on behalf of the company, that plaintiff is under the law incurring these legal costs as they go forward, whether they have whether they're actually paying them on an hourly basis, their contingency, but they're still viewed as paying those expenses. And then at the end of the case, and as 806 says, because when you look at 806A, it says, except as otherwise provided in B, all the money goes to the company. And B talks about how directly to the plaintiff is who you pay the attorney fees and costs. And so the plaintiff has brought this suit on behalf of the company, and all the money that the compensatory damage is going to go to the company. But the company did not incur the costs of bringing the suit, those legal fees. And so the plaintiff did. And so the plaintiff gets those costs back.
Okay, so the company,
and that's not a change from Oregon law. That's current Oregon law as well.
Okay. And Keel, I guess I would look to you too as a litigator to make sure this all seems right. This isn't my area of the law. Just wanting to make sure people aren't having this disincentive from bringing any derivative claims to the extent they could.
I mean, this is I think exactly how you'd expect a derivative claim to work.
Okay.
So there are lots of reasons.
Yeah. Okay. Go ahead.
I was going to say I don't think there's any disincentive to bringing a derivative claim in here that doesn't already exist. And there are lots of reasons you wouldn't potentially want to bring the claim. So.
Yeah, I mean, so I think where we leave it is that generally it makes sense to us, but I would like folks' perspective who are going to be commenting 901 to comment on the addition of expert fees there. Is there, I guess one of the things that after Cliff's comment that makes me wonder is, should it be more of a reasonable expenses standard than this I guess magic language that we've got in where it has attorney's fees and expert fees and costs. I mean, would it make more sense to strike everything after reasonable expenses?
Well, Oregon law, a lot of jurisdictions treat attorney fees as a subset of costs or expenses. Federal law does that, for example. Oregon law does not do that. Oregon law makes a clear division between attorney fees and costs. Okay. The question under Oregon law, because the assumption under Oregon law is costs means just the few costs that you can get under ORCP 68. The question is the language in ROLCA here sufficient under our sort of magic words requirement to have the reference to expenses and costs bring it within what's recoverable, expert fees and things like that. I mean, that's the biggest category of non-ORCP 68 costs. Is that language sufficient to achieve that goal under Oregon's law?
You just muted yourself.
You muted yourself.
That's weird. I didn't.
No, it was my bad. It was a loose mic.
Oh.
Sandy muted you.
I said the magic words that make Zoom mute me.
No, it was an accident. Sorry.
I guess I'm talking too much.
Okay, so Cody, what I'm hearing then is that Oregon law would not favor simplifying this section to just be reasonable expenses, because then attorney's fees wouldn't be in the bucket of things they could recover.
Yeah,
that would be a big change.
Yeah.
Yeah, it needs to specifically say attorney fees if we're gonna.
That makes sense to me then. So if you guys could ask about the expert fees, we'll circle back on that. I'll add it to my list. Anything else on 806?
Yeah, so then C.
intended to prevent collusion.
Yeah, and C is fine, and that same concept is already in 63801 sub 3. 801 sub 3 goes on to have a second sentence that's not in ROLCA. This is another one of those things where I think this is an inherent ability of the court to decide to do this, although the Oregon statute makes it mandatory, which is if the court determines that a proposed discontinuance, or in the words of ROLCA, dismissal, if the court determines that a proposed dismissal or settlement will substantially affect the interest of the members or a class of members, the court shall direct that notice be given to the members affected. And many states have that kind of language, many don't. I'm fine if we, me and Kyle and Aurelia are fine if we keep that in. We're also fine taking it out and just making a comment being, we think that's inherent authority. So we're sort of agnostic about that second sentence. But the first sentence, the part of ROLCA there, is something we definitely think we should adopt.
I like the idea of adopting the second sentence of 638013 and adding it to 806C of ROLCA.
Mm-hmm. Yeah, I agree. It just seems more user friendly.
Yeah.
Okay.
Okay. So yeah, I'll make my note there. Okay. So then the next thing is, it's not actually part of ROLCA at all, but there are two other issues that are raising things that are issues under Oregon law that I want to address, and that I think would make sense in the context of this 806.
Okay.
The first is right to a jury trial on a derivative claim. The Oregon Court of Appeals 9 months ago held that derivative claims are subject to a right of jury trial as a matter of the Constitution. You have a constitutional right to a jury trial on them. That case is now before the Oregon Supreme Court. And full disclosure, I, a few weeks ago, filed an amicus brief for the Oregon Trial Lawyers Association urging the court to affirm the Court of Appeals opinion saying that there is a constitutional right to jury trial on these claims. I mean, as a matter of practice, these claims are always tried to jury trials and have been for decades. But there's this question whether in 1857, when Oregon Constitution was adopted, whether these claims were tried to jury or not. And then also there's a question of, did the adoption of the Oregon Rules of Civil Procedure in 1979 change anything? And under US Supreme Court case law, derivative claims under the 7th Amendment are entitled to a jury trial right. Some state courts have followed the lead of the US Supreme Court in that regard. Others have said, no, we're not allowing a jury trial right for derivative claims. Our recommendation is to just, regardless of what the Constitution says, make there be a statutory right to jury trial on such claims, which is consistent with Oregon practice in any event. And so that's our recommendation there.
Isn't, so you said that the case is still pending?
Yeah, the constitutional case is still pending with argument coming up in March.
Okay, so we're likely to have a decision before 2023?
We are likely to have a decision before 2023.
I know the
That's
courts
right.
are kind of in crisis right now. I mean, what you're saying.
I mean, and if the Supreme Court affirms and says there is a constitutional right to jury trial, then having a statutory right to jury trial, may be a moot point. If the Supreme Court says there is no constitutional right to a jury trial, that begs the question: should we have a then the only way you would have a right to a jury trial would be through the statute, and that would beg the question: should we have that in the statute?
I have no dog in this fight. How do other people feel about this?
I think we should follow what the court.
James, you always cut off the last half of your sentence by muting yourself.
Oh, sorry. I think we should follow what the court does.
think we should
would
not
agree
address
with
this
that.
at this time.
Say that again, sorry.
Sorry, I don't mean to keep talking over you, Michael.
Go ahead.
I think we
next.
should not address this at this time.
I would agree with Teresa. And again, I think this is an issue that I think it would be a mistake to not deal with this across all of the Oregon entity statutes. I think, you know, you have corporate derivative claims as well. You know, I hesitate to create an LLC statute that are basically going just to drive people to Delaware because it is so business unfriendly. So I think we need to be cognizant of, and Valerie, you've gotten at that a couple of times today, the political dynamic that we're creating here. So I think initially we should defer and see what the court comes down with and then go from there.
Yeah, I mean, I'm not, like I said, I'm agnostic. I don't have a dog in this fight, but I wonder if we have guidance from the Supreme Court and also we'll have a better idea where we're going with the Corporate Act before we actually submit this to, well, I mean, we'll get it to Legislative Council, but before it's introduced, we'll know the answer in your case, right?
Yeah, and also, you know, another, I guess, relevant fact is Davis Wright is representing the defendant in that case and arguing that there is no constitutional right.
You know, it seems to me that if the Oregon Supreme Court finds that there's a jury trial right and the matter is decided, then we don't need to do anything in this act. If the Oregon Supreme Court decides that it's not required to have a jury trial and there is a groundswell of people in the bar who think that we ought to have that, then that seems to me something that they could do by separate legislation and make that change across the board to all of the entity acts. And so to me, it's a question I think we ought to table for now, particularly since it's a live legal issue. And allow it to be addressed in the fullness of time.
Yeah, and it may be something litigation section wants to address because, you know, there could be a companion bill to this that allows, you know, some of these litigation specific issues to be addressed in parallel with the main bill too. Just thinking of process, you know, so to the extent that there's a compelling need that litigation section identifies, you know, I'd be curious about Susan's thoughts about how we could, you know, like this, we could have their main bill that would become 63A, you know, and work through all the nuts and bolts of that. But then to the extent that there are other sections that think there's something compelling that we need to discuss in tandem with the adoption of the 63A that we're talking about in this group, you know, I think that is something that makes sense to me too, as a strategy to address some of these issues. You know, and I don't know, like I said, I'm not opposed to it, but I agree with what Teresa's saying, and that, you know, if we're going to get a Supreme Court ruling on this before we get to the adoption, then it may be moot.
Yeah, I'm happy to you know, table this until.
No, thank you for raising the issue, though. I appreciate it.
Yeah, and then one final issue to raise on a 806 related issue is the question of whether we should adopt for LLCs a mechanism that is currently available to Oregon corporations. Kyle and Aurelia and I ultimately didn't have a strong feeling either way, but we thought it was an issue of interest that we thought that we'd solicit the group's input on. This is not something that's part of ROLCA, and it's not something that Washington or California has for LLCs. What this statute I'm referring to is RS 60.952 sub 6. And what it says is when the plaintiff brings a claim that is involving issues that might, you know, for among other things, result in, you know, dissolution of the LLC or money damages, things like that. And what it is it's 6 says if you bring within 90 days after the plaintiff brings this suit, the corporation has the opportunity to do a forced buyout of the plaintiff for an amount that, for fair value, which if not agreed upon ends up getting settled by the court. And if the election to buy out the plaintiff is made within that 90 days or such later times the court may allow, then the plaintiff is going to get bought out and the claim will not be litigated, and that'll be the end of the matter. It's sort of a relatively quick and easy way to end these kinds of cases. And that has some pros and it has some cons, which I can put into more detail here for everyone. It is a statute that often ultimately gets invoked in LLC cases anyway. There's a lot of corporate statutes and things that, because that act is just so much more detailed than the LLC one, I think in a lot of LLC litigation, corporate law gets borrowed. But there isn't this right under the Oregon LLC Act or under ROLCA to force a buyout of the plaintiff on the company's election. So we want to bring.
Am I the only one having difficulty hearing Cody?
No,
No, we can't hear either.
Cody, you're breaking up.
I think your internet connection's.
Sorry.
Hello? He's frozen.
Can you hear me now?
Yeah, there you are. Oh, you're still kind of pixelated. Aurelia or Kyle, do you want to leap
Hear
in?
me?
Cody, you could turn off your camera and that might improve your bandwidth situation.
Okay, can you hear me now?
Yeah.
Okay, sorry, I'll be a box there. But I can go into more detail on this. I just thought I would pause before I do to give people an opportunity to say anything they think, or I can't tell it really. You look like you maybe are wanting to say something.
Well, I just wanted to add, I mean, it's sort of a unique provision in Oregon's corporate statute. And when that was adopted, it's something that they sort of made a concerted decision to include. Not a lot of other states have this provision. And it's often thought of as a sort of no fault divorce kind of proceeding. It comes up in the context of deadlock or oppression type claims. And it essentially stops litigation except that bad acts can come into the valuation proceeding to the extent they affect the fair value in that determination. But it otherwise, really truncates the proceeding and allows the parties to, end things and go their separate ways while still compensating that minority shareholder with the fair value of their shares. So
it's just the fair value of their shares, right? It's not other damages that they may have suffered.
That's right, except to the extent that like the breach of fiduciary duty or oppression somehow affected the value of the company itself.
Yeah.
Yeah, just to add on to that, if the individual has individual claims, they're not resolved by buying out their shares, but it resolves any derivative claims. And I think that this is something that can be altered by the operating agreement. So basically what you're doing is setting up, unlike most other states, but you're setting up a default rule especially for those for people who set up an LLC and may not be giving any thought at all to to what happens if things go sideways, and you set up a somewhat.
So I apologize, I may have misheard, but I thought this was in chapter 60. So does it apply to LLCs?
No.
No, but a lot of people do analogize to the corporate statutes when bringing LLC litigation for things that aren't fleshed out in the current LLC statute.
So it's kind of up to the court whether they want to apply that by analogy.
Right.
For those of you who litigate in this area, and this is a statute I've never come across before, has it been useful?
I think overall, yes. Not everyone elects to do it, but it does. it does reduce costs. I mean, it reduced the issues in your trial. It really substantially limits the proceeding, and it's designed to, allow people to have this one case about what is the fair value, and then sort of have everybody move on with their lives.
I have to admit, I kind of like the idea. If it actually works out at least some of the time in practice to be useful, then I would be in favor of adding this.
So Aurelia well described some of the pros. It reduces the litigation by turning this lawsuit primarily into a valuation suit, although sometimes the merits of the plaintiff's claims can get brought into the valuation dispute. But I also there's some cons to it. Among other things, and in particular, like you think about your carpet layers and the way that other people organize their LLCs, sometimes distributions from the LLC is not the primary money that you're getting out of the LLC as a member. Oftentimes you're also an employee and you may be getting paid that way, and that may be your more significant income from it than even the distributions. Or, for example, it's a family company and you have, the one family member may be abusing the other family member, but they're both working at the company, and that is where the one member has worked all their life, for example, and then they get kicked out of the company, they get bought out by this, and so the value of their ownership interest in the company, they get compensated for that, but they don't get compensated for any loss of future salary or the other hardships of then having to maybe switch jobs or career at whatever age or experience level they are. So there are some costs, and like I said, although this Oregon statute is part of the Model Business Corporation Act, and was before ROLCA was last amended. I mean, it's been part of the MBCA for a long time. ROLCA did not adopt this, and so far as I can tell, no state has adopted something like this for LLCs. But it does have some pros to it. And so we thought, I have plaintiffed a case where the company made the election on the 91st day. And we were glad that they missed their time period. And we ended up getting a multi-million-dollar judgment against the defendant in a derivative case. And, so I've seen where we didn't want to be bought out, but also, there's a lot of value to being bought out. It reduces friction between business members. I mean, it just makes them so they're not business partners anymore, and they move on. So there's pros and cons to it.
I mean, I feel like this is a situation that you can already address in drafting your operating agreement, though, right? Where there's conflict between the members, you can provide for a pressure valve already. So if we were to adopt something similar to 6952, would there be changes to 801, the direct action provision, that would be appropriate in relation to adopting something like that?
I don't think it would change what we do with 801.
Okay. Yeah, I don't think so either. And I think we're suggesting that this would be a default provision and you could vary it, in your operating agreement, get rid of it.
Yeah.
Yeah, I guess what I like about it is that I see a lot of nasty business breakups and disputes because they end up in the insolvency world eventually. Right. When people spend all their money on attorney fees fighting these fights for a really long time. And maybe my view is somewhat skewed because of that, but I think that whenever one member or shareholder of a company starts suing the others, it creates an atmosphere of general unpleasantness that even the dismissal of the lawsuit is not going to put them back to the relationship and the type of business that they had before. And sometimes having a cleaner and earlier break is just a lot of less angst and anxiety for people. And it's probably better that people move on than try to regain what they had before the lawsuit was filed. And for the people who are in the situation where, this is their livelihood and they're worried about never being able to find another job, or they're concerned that they're going to have to change jobs, you know, that's a factor in whether they decide to bring the lawsuit too. And kind of actions have consequences in this world. And if they bring that lawsuit, then that's one of the consequences that they have to be prepared for. But I kind of like the idea of at least putting in the possibility of a swifter and easier business divorce into the works as something that the company can do, and just say, look, you know, if you're going to sue me, we're just done. Let's move on. To me, there's a lot of advantage in this. And I mean, maybe you could vary it by the operating agreement, maybe some people would, but it looks really attractive to me.
I totally agree. I've never seen this before. I'm surprised you found such a creative, interesting little provision that I've never come across. And
Yeah.
I could see this being totally useful and eliminating so many fights. You know, let's focus on what really matters, the financial interest, and move on. I think it's great. And I mean, we could pitch it that we're trying to harmonize the business acts, right?
Yes.
We're clearly going off the menu, but at least we're harmonizing existing corporate law with the LLC Act.
Yeah, I would agree with James. I think it could be a helpful tool. If memory serves, I think this came into Chapter 60 after some of what occurred in the litigation amongst the NATO family, because it looks like it came into the statute on 2001, quite a bit later than the initial adoption of the Revised Model Act here. And you look at that case and, you know, kind of play into the provisions of 952. I think there's some helpful tools that can bring resolution to what otherwise could be very protracted, messy litigation. So, and I think the harmonization point that James made is a good one as well.
There would have to be some, first of all, can you all see and hear me okay?
Yes.
There will have to be some tweaks to that 952 sub 6 to make it fit the LLC Act model. But we didn't take the time to make those tweaks because we thought we'd see if the concept was of interest first. It seems to me there's enough interest in the concept that it's worth us wordsmithing it.
Yeah.
A couple things to note as well is that when you do the valuation, they don't take into account minority discount or marketability discount because in part because the statute is, you know, it's often talking, the claim that the plaintiff is bringing is about oppression or things like that, mismanagement, waste. And also the statute, the corporate one, applies only to small, closely held companies. Whereas, you know, and we can try to define what that means in the LLC concept, or we can just have this apply to all LLCs. But I just wanted to raise those points. And under the corporate statute, it applies anytime that you're bringing suit because the directors are deadlocked, or when you're talking about illegal, oppressive, fraudulent, wasteful conduct. Whereas I think in wordsmithing it, we'd have to be talking about, you know, when the plaintiff is suing for breach of duty of care or loyalty or, you know, things like that, which includes some of those same terms ultimately when you define what those fiduciary duties are. Anyway, but it sounds like we'll just wordsmith something and present it next month.
Yeah, I have to say that, Cody, when you said minority discount, my ears pricked up a bit because I wonder if this would have any effect on valuations for estate tax purposes or for estate planning purposes, whether that would limit the ability of Oregon folks to apply minority discounts for estate planning purposes.
I don't think so, Roberta, because I think it's arising in a separate context. I mean, you and I can talk offline about this.
Yeah, okay.
Circle back to it as
you think we're okay though? You don't think that's gonna?
I do think we're okay. I don't think it's an issue because, you know, I think to the extent that you had a claim as an asset of the estate, it would be sort of its own thing. It wouldn't be the underlying shares you're trying to value, right?
Well, no, you might be, particularly if you were doing a transfer to a family member in the context of an estate planning.
Right, but the idea of transferring assets out of the estate is that, you know, you're looking at what the value is, right?
Yeah.
And so, you know, and just talking off the top of my head here, I don't think it's an issue, because I think that, you know, the same logic that underlies the lack of giving those discounts in the litigation context, it would make sense in the estate planning context, because that's what they have, right? As opposed
And I
to,
guess because it's only limited to a situation where you are in litigation and where there has been a breach of fiduciary duty or something like that, which is not typically what you'll. Okay, sorry. Yeah.
And we may not have discounts in the estate administration context for much longer anyhow.
Well,
so.
you never know.
Nothing about that, but this is it's a term. Fair value is a term that's defined by the case law, and that's the term that's used in this statute. So it's different from fair market value, for example.
Right. Yeah, I think that's a good point, Roberta, but I think that it's just different. So I would be curious to see some sample language maybe next time, as for a, you know, whatever 807 would look like in this area, and then we can talk about it. I'm also curious what Mohsen's going to have to say about this, because I'm sure he's got an opinion. So would you mind roping him into those discussions?
Sure.
Okay.
Yeah. So that was it for what we had sort of as off the ROLCA menu. So the next thing is to go to 105C11 of ROLCA.
Right, which is on page 23 of my printout.
Right, yeah.
Page 23.
And so this section says that you can, you know, normally, again, the default rule is that you can modify all the provisions however you want through your operating or through your operating agreement, but you may not unreasonably restrict the right of a member to maintain an action under Article 8.
Right.
And so I'll put aside the issue of, you know, whether we're going to adopt 801, you know, such that whether this applies then to only derivative actions or whether it applies to both. What does that mean to unreasonably restrict the ability of a member to bring a suit? The commentary seems to indicate that it's extremely broad. There's very few things that would be unreasonable, or at least there's very few things that they identify as being unreasonable. They basically talk about what is reasonable for the most part. They say a forum selection clause is reasonable. Mediation and arbitration clauses are reasonable. I think everyone would agree all of that is reasonable. Yeah. They say liquidated damages clauses are reasonable, something I don't necessarily think is reasonable. Remember how when you do your demand, you have to make a demand before you can bring a derivative claim, unless it would be futile to do so, which usually is because the board members are here, you know, the LLC member implicated in some way. They say that it would be reasonable to override that futility exception and do what's called universal demand, and basically make the plaintiff have to make a demand on the company, even if the company, you know, the company's not going to do anything about it. They say that on 801.
Wait, I'm confused now.
What, are you muted yourself again, or Sandy muted you?
Okay.
No, I muted myself, but I'm going to stop my video because it said I had an internet connection problem again.
And I'm sorry, I'm confused, as is so often the case. So I'm reading the comments to C11, which may have been what you were reading, Cody, and then it does say that it's reasonable to require universal demand, but then it also says it's unreasonable to require a derivative claimant to make demand regardless of futility. So
Well, so yeah, it took me a few reads to understand what they were saying there. And what they are saying is that universal demand requirement is reasonable. What they are saying is not reasonable is to both require the plaintiff to make a futile demand and bar the plaintiff from suing no matter how long the company ponders the demand. Because then you're giving the biased company the ability to, just by sitting on the demand forever, prevent the plaintiff from ever bringing suit. That is the only thing that the commentary indicates would be unreasonable, is if you were essentially, completely killed the ability of a plaintiff of a member to bring a suit. All the other instances of situations that they describe are things that they describe as being reasonable, including universal demand. But again, remember that if all you're doing is requiring universal demand, there still is the provision that says that the company has to act within a reasonable time on your demand. Now, granted, you could under this, you can't, apparently it would be unreasonable to both get rid of the unreasonable time and also have a universal demand requirement. And the only other thing is in the commentary to 801, where they talk about what might be reasonable or not, they say that the standing provision of 801B, meaning that clause that describes what is a direct versus a derivative claim, they say that you can revise what that is, and that would be reasonable as well. So they give a lot of examples of what they deem as reasonable. They give only one example of what they deem unreasonable, which is the absolute most ridiculous extreme example, which, but they don't really talk about what else they view as reasonable or not. And despite ROLCA having been around for, a substantial number of years at this point, there is no case law interpreting this reasonable term. What would be reasonable here? Some states have.
I just want to see, I want to sort of put a pin in where we're going with this. So is your recommendation going to be to strike the unreasonably language?
More nuanced than that. Our essentially our recommendation is going to be, to strike the unreasonable language, but then to just explicitly state the changes that we think that LLCs should be able to make, such as forum selection clause, okay, mediation, arbitration, okay. In a sense, to explicitly state the changes that are okay to make, and then therefore all other changes are not allowed, rather than leave it up to this totally undefined reasonableness standard that the implication of ROLCA is that most any change is reasonable. In other words, you can do just about whatever you want to modify direct and derivative claims.
Mm-hmm. Are you sure we can think of everything that should be reasonable and everything else should be unreasonable?
No. I'll point out that, Washington and California adopted this C11, but Alabama, Illinois, South Dakota did not.
I don't think we want to follow any of those states.
I was going to say.
Really? Yeah, have something in common with Alabama.
South Dakota.
Yeah.
No, I definitely don't look to Alabama or South Dakota usually for
But
good law.
I think it's good to have a list of things that are reasonable, but I would just maybe say that including but not limited to.
Well, I also think that this may be an appropriate thing to put in the comments. Because we've talked about developing our comments for this section, and I think, our comprehensive list is probably not so comprehensive, right? And so it makes more sense that we would say, okay, here's things that we view to be reasonable. Here's things that we think Oregon law views as being unreasonable.
Valerie, I would agree with you there that I think this is an issue that we can talk about in comments, and also agree with Roberta. I don't think we should attempt to have a crystal ball to perceive all the different ways that this could manifest itself in the context of particular facts. Let the court decide what is unreasonable and reasonable. That's why we have courts to look at the peculiar facts of a given case. I think we should leave it as it is, but maybe deal with some of these issues in comments.
Yeah, and also, I mean, sort of generally, the whole premise of this statute is that LLCs are very flexible and you can do almost anything you want. So it makes sense that most things are reasonable, and that it would be relatively rare that something would be unreasonable.
I also wanted to point out that this is a change. It's a significant change to Oregon law. Currently, Oregon law in 801 sub 2, as we were discussing before, it allows the operating agreement to modify the demand requirement and the plead it with particularity requirement, but otherwise it doesn't allow any other limitations or changes to direct or derivative claims that a member might bring. So this would be an expansion in allowing those things.
I don't know if I entirely think that you would get a judge to do that, though. I mean, if somebody did something really radical in their operating agreement that said, you're just flat out not allowed to bring these claims, or you can bring them, but you can only bring them in the Northern District of Alaska, or something just completely ridiculous. I can't imagine a judge really enforcing that anyway.
I don't know, if you have a company that's an Oregon company, but its primary business operation, the big factory is in Alaska, I don't know why you couldn't have an Alaska foreign selection clause.
I was trying to posit something that would be completely unreasonable under the facts and circumstances of a case. And
Right.
in other words, when you've got the fraudsters who put the company together and they're convincing the innocent investors to put their money in and buy membership interests in this company, but they intend to scam those people all along. And because they want to protect themselves from lawsuits by these investors, they decide to say, you can't sue us, you can only sue us in the most inconvenient forum ever, or you have to, walk backwards sideways on Tuesdays for 3 miles before you can bring your lawsuit, or whatever ridiculous sort of thing they put in there to make it hard for people to sue them, then I can't imagine a judge in equity is going to enforce those anyway, if you're dealing with like scammed investors.
Right. I guess part of my concern is when you have that judge who's looking to determine whether something is reasonable or not, what they're going to be looking for some standard to apply. And, when you look at the commentary to Rolka, for example, the commentary gives, like I mentioned, only one example of something that would be unreasonable, which is, essentially a combination of provisions that totally terminates the ability of a plaintiff to ever bring a suit. And then it gives all kinds of examples, including, to me, for example, the liquidated damages clause. So you have a clause that says, oh yeah, you can do whatever, bad acts you want, defendant, other member, majority controlling member, and liquidated damages. So the plaintiff only gets, some small sum if they have a valid claim. And the commentary is saying that is okay. And so if that's okay, I mean, which it ought not to be, what else is okay? I just think that just merely having the word unreasonably in there gives no coherent standard to a court, and it invites a lot of changes to derivative and other such claims. I mean, for example, you can get rid of the ability for a plaintiff to obtain attorney fees on their derivative claim, for example, or you can, eliminate all kinds of other abilities to recover. You can limit what the damages are. You can limit discovery. All kinds of things like that, I would think would be pretty awful.
I guess, Cody, isn't that, given the LLCs are really up to the members to contract, determine those things? Isn't it up to them in most parts to determine whether something is reasonable, and if they can agree upon it, is, I guess, subject to a court's final determination, but they should be able to do that?
My view is that there's got to be limits. You've got to have the guardrails on the freedom of contract there. And, just like, and I know we've got a pin in what, in terms of the fiduciary duties, can they modify and not modify. And recall that Rolka says that you can eliminate all damages against a bad acting member. I don't think that's a good thing either. And I think we need to have a guardrail here that allows the plaintiff to bring a meaningful lawsuit if they've been harmed and get a meaningful recovery for that.
You still have, there is still that reasonableness standard. I guess I'm more in what I think is Roberta's position, where we kind of just leave it at the unreasonably restrict and let a court make that determination.
And I think it would be fine to
I
have
think we've got it.
I'm sorry, I was just going to say, I think it's fine to have a list of what we think is reasonable. I just didn't want, I'm just reluctant to say that we need to say these are the only things that are reasonable.
No,
I think it's okay to have a list or in comments or in.
I think for purposes of our job, I think our job is to look at 105, C11 here. Do we make changes to that? To the extent that we do, even beyond that, what should the commentary to that say? I mean, I think it's reasonable that there would be some examples that we set forth in the comments. But I don't know that we want to go too far down this road either.
Well, and this is, to me, when you don't have any definition of unreasonably, you really open it up for the potential gutting of all the other work we've done in Article 8. And, first of all, I think this is another thing that when we talk to the defense lawyers, we should see what they think about it. But it's one of those, explosive issues, just like with 105C, 7 and 8 that we currently are waiting to talk to. I think it was waiting to talk to defense lawyers about as well. It's one of those things where this is where the real politics of this will hit in the legislature with the business lobby and the trial lawyers. And it may be that the best solution is just to stick with current Oregon law on this and allow modification of the demand futility stuff and the pleading requirements, but otherwise not allow modification of direct and derivative actions.
Okay, so.
But for now, why don't we just talk to defense lawyers and see what they think and reconvene next month about it?
Yeah, and I want to make sure we get a chance to talk to Susan too, Susan and John, about the sort of the political aspect of that. So to the extent that we are going to make any changes though to C11 here, would you strike unreasonably and just say restrict the rights of a member to maintain an action under Article 8, or would you make other changes to that subsection?
Well,
I want to give these guys something to react to, some proposed language to react to.
Right. So the proposal that Kyle and Aurelia and I had discussed was to nix the word unreasonably, and then end that. So it would just have it read, restrict the right of a member to maintain an action under Article 8, but then move on from there and give an approved list of modifications that the operating agreement can make. And what we had come up with is, except that the operating agreement may require pre-suit mediation of such an action, arbitration of such an action, that such an action be litigated in a particular forum, and that the demand described in 8021 contains specified information and be made by specified means. Basically that last part being what Oregon law currently provides. So sort of giving an expansion of the authority of members to modify these actions by allowing the arbitration, mediation, and form selection, but limiting the expansion of the contractual right to that. And I agree with you, we couldn't come up with all the potential reasonable things, but we also won't be able to come up with a complete list of all of the unreasonable things. And
I mean, that's the job of the court too, right?
Right, but right now it's not the job for the court. Right now, those things are not allowed, period.
This is new language, right? So, you know, if we're saying what should we be deciding and what sort of things should the court be deciding, I'm okay having a court decide reasonable versus unreasonable more than I am having us do it. If that makes sense.
Valerie, I'm in agreement. Cody, has there been any other state that you found that, you know, other than Alabama, who's taken the position that it's just this limited set of actions that they can modify?
Well, so I didn't find anybody so like I said, Alabama, Illinois, I mean, I agree, Alabama, you know, they're not the state we necessarily want to follow for probably most anything, or South Dakota. Illinois, I don't have such a prejudiced view of Illinois, let's say. But Arizona adopted this, but then added the caveat that the operating agreement may impose certain requirements related to standing to bring direct actions. So they did have a sort of a specific tweak, but nobody else did what we are proposing, which is to sort of, you know, beyond Arizona, to go in more detail about what you can and cannot do here.
Okay, so I think in the interest of, because I don't think we're going to come to a decision today on this. So I think in the interest of wrapping up this discussion for now, what would be helpful, Cody, can you email the language that you guys had talked about to Sandy? And Sandy, once you get that, can you circulate it to the group so that the other folks can talk about it? And I want to get, and so when we send it to other folks, can you copy in what's currently in C11, which is the unreasonably restrict the right of a member to maintain an action under Article 8, and then also as an alternative have the proposed language that Cody, Kyle, and Aurelia came up with, because I'd like to get their reaction to those as a set. Does that make sense?
Can we add what is the proposal on dealing with liquidated damages? Because it seems to me that it is not unreasonable for a company to decide in advance as part of its operating agreement what liquidated damages would look like. I mean, there's already a body of law around whether liquidated damages are reasonable or unreasonable. And what is the group proposal as to how we address liquidated damages?
I mean, I think that would go in that list. So it looks like Cody just dropped that language into the chat window. So Sandy, if you could pull that up and email it to people so it's not just trapped in the Zoom world, that would be helpful.
Yeah, I already copied it.
Okay. And then I think having Teresa's suggestion of decisions with respect to liquidated damages as another option, potentially E, would make sense in there as well. Because I do want to get John's take on it. I want to get Susan's take on it, and you know, any lobbyists that might care to weigh in on it. You know, right now I'm not super in favor of the idea of following South Dakota in anything. So, but you know, I trust you guys. You're smart people, and so if you think this is a good suggestion, I think we should definitely give it due consideration. Okay. Anything else on 105, Cody, Aurelia?
No. So my understanding is on Article 8, there's going to be some chat with the defense bar on 801 about, you know, our proposal regarding defining direct versus derivative claim.
Yep.
806 about whether expert fees should be added to derivative suits, about what we should do about 105C11.
Yep.
And then the only other task list item is on this, me and Aurelia and Kyle and Mos, and we'll draft up some proposed language about that buyout clause.
Yeah, so potentially an additional, what we'll call 807 option.
Okay, that all sounds good.
And so we'll start next. Yes. Sorry,
yeah, I'm sorry, Cody, when you look at that 807 language, give some thought to whether the operating agreement can amend that.
Yeah.
Yes. Yeah.
Yeah, that's a very good point, James.
I think that if we, if we end up adopting that buyout provision, I would think that what we would probably want to do is similar to what Rolka did with the SLC concept, is allow the operating agreement to just kill that whole concept, but not allow them to modify it if they go with it. Because I would think it would be a real problem if you allow this buyout, but then you allow it to happen with marketability and minority discounts, such that there's almost no value there. Yeah.
No, I like the idea of it as a pressure valve, though, and particularly as there's some parallelism with the corporate act. Okay, so we'll start with that next time, and then James, you're up on Article 9.
Yes.
Yes. And then after that, I mean, next time I want to assign Article 10, but Article 10 is broken up into a number of different parts, and so I think we were going to assign each part separately. So give some thought to what part you might like to be involved in reviewing, and we can go from there. And now I'm going to go be completely distracted by C-SPAN, but I really appreciate all of your time. Assuming, as James says, democracy survives, we'll see you next week, or next month rather.
I think we're going to be all right, but thank you, everybody. I really
Thanks,
appreciate
everybody.
it.
Sorry for
I
the
just sent
connectivity issues.
Cody, the most recent language I just sent to the group. So everyone should have everything from the chat today.
Great. No,
Thank
I think
you.
this is a really good discussion, and I really appreciate your setting a land speed record and getting through Article 8, even though we will be revisiting it next time.
All right, thanks. Bye, everybody.
Bye, everybody.
Happy New Year.
Thank you very much, guys.
Happy New Year.